First case we'll hear will be a 20-minute grant, 20 minutes per side, Otto versus Inn at Watervale. Would the appellant please proceed?
Good afternoon. John Worsfold for Appellant, the Inn at Watervale. I'd like to reserve 3 minutes of my time for rebuttal, and I will waive free fire after 2 minutes. May it please the Court. The jurisprudential significance of this case extends far beyond the parties who are here today and impacts millions of landowners, businesses, outdoor recreational users, and conservation groups throughout the state. The determination by the Court of Appeals that beach day activities do not fall under the RUA's protections improperly creates classes of users, undermines the legislature's clear intent in expanding the scope of the RUA, and misapplies statutory construction where none is needed. Two different avenues can be utilized to reaffirm the policy and the purpose of the expansive scope of the RUA and to disavow the Court of Appeals intensity risk analysis test. First, the RUA as written and amended is simple, clear, and plain. No statutory interpretation tools are needed to determine if beach day activities are an other outdoor recreational use. The application of a justum generis in this context is improper, not just because the language isn't plain, but because asking whether an activity is of the same kind, class, character, or nature as the enumerated activities is essentially the same equivalent as reinserting the word similar back into the statutory text, which the legislature removed in 1974 by replacing the word similar with the word any. It is not the judiciary's role to ascertain if a use is similar when the legislature has expressly rejected such a limitation through its amendment. Moreover, the application of a justum generis was dictum in Neal and should not be looked at as a binding test. Secondly, even if the court finds that the application of a justum generis is not contradictory to legislative intent, there is no rational way to conclude that beach day activities, quintessential and historic pastimes in our state, are not of the same kind, class, character, or nature as the enumerated uses of the land.
So why is it so important to you to reject the idea that these provisions stand in a justum generis relationship with one another, if you're going to prevail in either event?
Your Honor, I'd like to cover my bases. And I don't know what this court's determination is going to be in terms of whether a justum generis does apply. I believe that Your Honor's writing in Neal, in writing for the majority, I think that the engaging of the dissent's mischaracterization of the majority's decision, I think that was dictum. It didn't affect the holding of the case. The holding in Neal was entirely on whether it applies to large parcels of vacant land.
So if there's no justum generis relationship, we should understand that all those specific activities are encompassed by the statute as well as any other outdoor recreational uses.
Well, I think that's right. I think
even if they bear no particular relationship to one another.
Well, yes. The answer is yes. They do bear a relationship to one another in many myriad different ways. There is no unifying singular thread between the enumerated uses because they all have different characters and moods and individual characteristics. It's difficult to say this is the one thing that they all share. And I think that makes the application of a justum generis very tricky. And this court has held in the case in re the forfeiture of $5,624, the court has held that the application of a justum generis is not appropriate when the singular specific words do not share a unifying characteristic.
Well, if you look at several words or phrases at a sufficiently general level, I mean, there's always going to be some common elements, and there's probably always going to be some distinguishing elements. I can think of some common elements that all the specific listings share with outdoor recreational activities, and you can probably conjure up some on your own. So it's not as if you can't unite them in some way. It's simply that I guess you think that you can only unite them at a overly broad and general kind of level, or a relationship that's that's just too broad or general to have much usefulness.
I agree, and I think that lies at the heart of the error of the Court of Appeals in looking solely to intensity level and inherent risk of the activities. The ways in which beach day activities, running on the sand, splashing in the water, throwing stones, all of those activities share characteristics with each of the enumerated uses, and the ways in which they share those characteristics is nearly limitless. The Court of Appeals erred when it focused on two elements, inherent risk and intensity level, which is not anywhere in the statute, it's not anywhere in the case law, and quite frankly, it's quite arbitrary when it begs the question, well, what is intense or what is inherently dangerous about sightseeing, which is an enumerated use? And that's a question the Court of Appeals didn't answer, and it's an issue that the appellees have been unable to address as well.
So if you've rejected that Latin maxim we've just been discussing, it's your obligation right now to show how beach walking, or however you would characterize the plaintiff's activity in this case, fits within the language other outdoor recreational use.
Certainly.
Why don't you make that argument, please?
Certainly. The activities that plaintiff and her companions engaged in that day, there were a host of activities. It included hiking a quarter-mile over a dune down to the water. It included lounging on their towels, and the adults were reading books. The children were splashing, playing in the water, and throwing stones, running around. Certainly they were engaged in sightseeing, as this is one of the most beautiful areas of the state.
But the statute was kind of clear in terms of the things that it specified, right? It gave a list.
It gave a list as to the enumerated uses of land. The catch-all phrase, any other outdoor recreational use, is much more broad and encompasses, I believe.
Then why did it give a list?
Because the catch-all provision, which was added in 1964, was in addition and an amendment. It was originally added to say other similar outdoor uses. It was amended in 1974 to then remove the word other and include any. The key is, and this is what I believe, is that when you look at the original text from 1953, it included only hunting, trapping, and fishing. There was no catch-all, and there was no indication that it only applied to recreational uses.
But hunting and fish, those things are high impact, aren't they?
It depends on the character
Hunting?
in which it depends on the character in which they're engaged. I find it difficult to see how sitting on an end of a dock and throwing a night crawler with a bobber into the water and sitting there is a high impact, high intensity endeavor.
But they're activities with a focus, are they not?
They're recreational activities with
a focus, though.
Certainly.
Okay.
But when the text was enacted, and even as the text is written today, there is no limitation on the enumerated uses that they be recreational in nature. The only limitation that the word recreational applies to is the catch-all provision. The enumerated uses, one can avail themselves of the protections of the RUA even if it's a commercial trapping, as long as they're not paying a fee. An educational hike over a nature conservancy ground falls for protection under the RUA.
Does it matter what the danger is?
No.
It doesn't.
Unless it's ultra-hazardous.
Okay, so like in this situation, does it matter if it's a man-made danger or just an inherent danger? Because the other case that you cited, basically, the person got injured due to the ground, or that there was a crevice in the ground. This is a situation where we had hot coals that the person stepped on. So does that have any bearing in terms of how I'm supposed to look at this?
No, the jurisprudence of this state does not make a distinction between man-made hazards or naturally occurring hazards.
So under your kind of reading of this, let me just give a hypothetical. In this situation, you had people that, you had a child that burned herself on hot coals. I guess let's give a hypothetical. Hypothetical, let's say I love to walk. Walking is one of my favorite activities. So let's say I'm walking and on a beach, but instead of it being like a nice recreational beach, it's a heavy industry area. There's a factory that's next to the beach. And for whatever reason, they have some really man-made dangerous things that they kind of put into the ground for whatever reason. And let's say I fall on something which is man-made but is incredibly dangerous. Are they exempt under your argument?
As long as they're...
I'm walking on the beach, so I don't know if it's high impact or not, but I'm walking on the beach. It's a public beach, but I'm sorry, as you said, that the beaches are, it's owned by someone, but I have access to it. So I'm traversing the beach, but for whatever reason, let's just give a better hypothetical. Let's give sometimes those like fancy hotels, they have those fire pits that they like to do things with. So there's a fire pit and it wasn't attended to, and I walk into the fire pit. So, which for me wouldn't be such a far-fetched thing. So the question I would have is there anything man-made under your analogy that would create an inherent danger that would ultimately still allow for liability of the landowner?
Yes, if the man-made danger and the either failure to warn or the failure to inspect was characterized gross negligence or willful and wanton misconduct, which almost presumes that it's ultra-hazardous in nature. And in this case, we're dealing with a very common occurrence, beach fires in northern Michigan. The danger hidden beneath the sand is no different than beach glass or pop tops or biting insects.
Well, it's a hot coal, though, isn't it? It's still a hot coal.
They're hot coals that have been concealed. And the fact of the matter is no one knows who made the fire, who covered up the fire. There's no indication that it was an employee or a guest of the inn. No one knows. And it is a naturally, quite frankly, it's somewhat naturally occurring happenstance to have beach fires along undisturbed shoreline in northern Michigan.
So under your argument, then, a person like myself who is walking on a beach, even private beach, but I have access to it because it's a public property or a right of passage. If there's a danger like a fire on the beach, and the fire isn't attended to, and I walk into it, then ultimately you would contend that there is no liability of the landowner at that point.
I would for several reasons. Number one, that a fire on the beach would, if as long as it wasn't concealed, would be open and obvious. And as the current state of the law is in Michigan, it's an objective test of whether a condition is open and obvious, and it wouldn't change depending on the nature of the user's ability to perceive it. Secondly, just having a fire on the beach, I don't think that rises to the level of gross negligence or willful and wanton misconduct, which, again, having someone, we don't know who, cover up a fire with sand on a beach, that doesn't rise to the level of gross negligence or willful and wanton misconduct. Certainly, there's no evidence or indication that the inn or any of its employees had a reckless indifference tantamount to an intention to harm. Okay. It's one of those things that kind of happens. The question that this court has been asking and is looking to are beach day activities and other outdoor recreational use? And it's our position that, as written, the phrasing in the statute, any other outdoor recreational use, that is as broad of a term as can be. When you remove the word similar and replace it with the word any, this court has held that any is equal to meaning every. It is all-inclusive.
Are there any, do you think there are any limitations on the scope of that phrase? I've been just trying to figure out does it apply to someone injured, doing something outside that even if that's normally an inside kind of activity? If I'm watching a movie out on the beach? That drives to
the heart of, I think, the difficulty with this area, and based on some of the language in Neal. Right. The test that I think this court should adopt is very simple. Is the purpose of the activity recreational? If so, is the use of the land necessary or inherent in achieving the purpose of the recreational use?
So watching the movie wouldn't be necessary. So that's how that would be a limiting principle that would...
Yes, I think euchre, cribbage, working a crossword puzzle, playing checkers, pin the tail on the donkey, or shuffleboard. Those are recreational activities, no doubt. but they don't use the land to achieve the purpose of the recreation. And I think that is the distinction and difference. Because if this court doesn't want to say every outdoor recreational activity is covered, which this court has.
Well, maybe that's the purpose of ius justum generis, to compare the any other outdoor recreational activity to the specific listing that precedes it. That's the harder argument for you to make than simply the argument that this is or isn't an outdoor recreational activity. I think at least for those of us who think that Neal versus Wilkes made some sense in terms of characterizing this as a ius justum generis relationship, you might want to compare what would occur in this case with the specific activities delineated in the statute. I think it'd be wise to do that.
I agree.
Well, your time is about 2/3 up, I guess. You might want to do it soon.
I'll address that right now, Your Honor. The nature of the activities that Bailey Noble and her companions engaged in that day share many characteristics that are of the same kind, class, character, and nature as hunting, fishing, trapping, camping, sightseeing, motorcycling, and snowmobiling. First of all, hiking over a sand dune down to the water's edge. I mean, that is hiking. Being at Lake Michigan on a mile-long stretch of undeveloped, undisturbed natural Lake Michigan shoreline at the foot of the Arcadia Dunes Preserve, that is sightseeing. You're going to the beach in the most recreational use possible, and sightseeing the second largest body of water. They share inherent traits and qualities with the enumerated uses. Hunting can be very meditative and peaceful for some people, and for hours and hours and hours. And on a dime it changes and becomes very exhilarating, heart-pounding. So too can a day at the beach. Relaxing and meditative as we soak in the sun, as we read our books, as we watch our kids splash.
So if there's a wedding at the beach and a wedding guest is injured the same way the plaintiff was injured here, not cover
a
what's the answer?
A wedding isn't a recreational use. That's a religious use. And because it's not an enumerated use, which can apply to recreational, educational, commercial uses, because it's a part of the catch-all provision, I don't believe that attending a wedding on the beach is a recreational use of the land. I think that if one is at the wedding at the beach and the wedding ends and now people say, hey, we're going to go for a swim, now they have the purpose of using the land to engage in a recreational activity. And I think that's a distinction with your example.
So I'm not recreating if I'm at a wedding? I'm not part of a recreation?
What if you're at a tiki bar on the beach after the wedding?
Then, well, as long as you're not paying consideration, then I think...
It all blends together, because some people don't think of a wedding, frankly, as a religious use, right? And they think of the wedding as the party, and the party on the beach. And if the beach party is where people do things that you can only do on a beach,
then I think that the germane inquiry is in the user's intent in using the land to achieve the recreational activity or achieve the recreational purpose. And that's a fact-based question.
That question, the way you framed it, that's this Latin phrase. You're using this canon of construction, right? Ius justum generis.
Yes.
You're applying an outside classification. That doesn't come from the language of the statute, right?
Correct.
You just think that your client's situation, there's no way to come up with a categorization that doesn't include your client's use of the beach, right?
Well, my client owns a beach, but
Sorry.
No, it's okay. The doctrine of ius justum generis is one that this court has applied in this context before. I'm advancing that, number one. I don't think that that is necessarily the most appropriate thing, given the legislature's clear intent in not looking at whether an activity is similar. If the legislature wanted to know whether the other outdoor recreational use was similar, it wouldn't have deleted the word similar and replaced it with the word
No, I understand,
any.
but I guess my point is that I understand your argument as applying that same principle. Am I wrong?
No, you're not wrong. Either way, I think we come out on this because it is hard to fathom how beach day activities in totality are not an other outdoor recreational use in this state.
You keep going back and forth either way, but you still haven't given a definition, a standard, a common relationship that these listings these justum generis listings have with one another.
Well, I have, Your Honor, and I'll repeat it.
I guess I missed it.
When they hiked over the dune down to the water, that is hiking. Hiking is an enumerated use. When they were at the water, at the beach, on a mile of lakefront property, that is sightseeing. They are engaged in sightseeing. It is one of the greatest sites in our state. Those are two enumerated uses, and those are exactly in the same
I believe your
manner.
obligation is to take the listing of things preceding the general phrase and show what they have in common, and then try to bring that to bear in showing what other outdoor recreational activities share that thing in common that the specific words have in common with each other, and you haven't done that.
May I answer your last question?
Well, please
And
do.
conclude?
Your time is up, of course.
The grand point is that they share the fact that they use the land to achieve the recreational purpose. None of the enumerated uses can be done without a use of the land. And the recreational activities contained in the catch-all provision, in this instance, beach day activities, require one to use the land.
Why
to
doesn't
achieve
pin the
purpose.
tail on the donkey bear that relationship, given that you have to stand on the land somewhere, you have to put the target somewhere downfield on the land, and you have to make sure there's nobody in the way on the land as you try to pin the tail on the donkey by whatever means that's traditionally done?
Because engaging in pin the tail on the donkey doesn't use the land to achieve the purpose. It is done on the land, and just because an activity takes place on the land does not mean that it uses the land under the
So it has a
recreational-
connection with the outdoors. It's not just incidentally performed on the outdoors. It bears some more fundamental relationship with the land. The land is not just the venue. The land is necessary in some way to that activity being carried out. Is
Yes,
that
and that
correct?
is stated more articulately than I. Thank you.
Are there any other questions? Okay, thank you, sir.
Thank you.
Thank you. Mr. Hanley?
Good afternoon. My name is Matt Hanley. I'm on behalf of appellee Kerri Otto. I guess I'll waive my 5 minutes. I have one thing I guess I can say to try to connect why we're here today. It's a guess, and thinking that if the intensity test is not one that's appropriate, I mean, of course, I agree with it. I think there's a second side to that coin from the Court of Appeals, and that's really looking at the probability of, the potential for harm, the likelihood or the magnitude of an injury that could occur, and whether the landowner should have some sort of burden to warn the licensee on the property. I think those are considerations that we find difficult to achieve, and the legislature could have a difficulty in thinking about those types of activities for a landowner to warn someone who's off hunting, fishing, or hiking, motorcycling or snowmobiling, where there's a likelihood that harm could occur and that the injury could be rather significant. So I think that's maybe the framework where we could.
Well, Counsel, can I just posit what I see as being at least an arguable common relationship or common substance that each of these things in Section 73301 bear in common. They are traditionally each performed outdoors, sometimes necessarily so, but they are each traditionally performed outdoors. And as I just suggested a few moments ago, and the opposing counsel, I think, agreed with me, they bear some more fundamental relationship with the outdoor other than the fact that that's the venue in which it's performed. They have a more intimate connection with the outdoors. So there's a connection with the outdoors, and they're traditionally performed in the outdoors. If I'm observing that they all have those things in common, the question becomes, does what the plaintiff was doing in this case also adhere to those same kinds of relationships? Does it conform to those same kinds of relationships? Do you think it does or doesn't?
I think building a sandcastle could.
Well, what she was doing, I'm not speaking hypothetically now, I'm asking specifically what the plaintiff was engaging in here at the time that she was injured. Was that something traditionally performed outdoors, and does it bear a more fundamental, intimate relationship with the outdoors beyond simply occurring in that venue?
I would say no. I think we're talking about a kid running around. A kid can run around.
So you would characterize it as running around, and you can run around in the house, so you can run around outside the house.
That's correct. I think, and also if we're talking about the order asked for what the parents were doing, they were reading a book.
Is there anything distinctive about beach running, beach walking, beach hiking, beach sightseeing? Is there anything more specific such that you can compare things at a lower level than simply running around?
You can, if you want us to talk about a beach, I think there's nothing distinct about the beach that, well, one, maybe Neil doesn't, I would think that Neil addresses this and saying, well, why are we talking about this type of land as the issue? I think on the second hand, it doesn't have to be a beach, so it's tough to drill down to that level when you can say backyard. I mean, if you want to say outside, yes, a child can run around outside in their backyard.
Okay, well, you're making a distinction. I appreciate that, and that makes a lot of sense. My first question to you was, do you think the two things that I identified as the listing sharing in common, the qualities that the listing bore in common with each other, is that an accurate assessment of what relationship these things have in common with each other that needs to be assessed when you try to give meaning to other outdoor recreational activities?
Yeah, I think that there is fundamentally these activities are performed outside. I don't think there's not going to disagree with that.
It's not just that they're performed outside, but
and have a relationship, an inherent relationship to the outside.
So you don't think the test that I articulate is necessarily a wrong test, or the standard's necessarily a wrong standard. You just think I may be applying it at too broad a level.
Correct.
Okay. Do you want to develop that further?
Well, I think that leads us down the right, how broad we're going to go. I guess I'm trying to put limits on that because I can't imagine the legislature would think that child's play, I guess, I mean, you have to go in to look at what Neil said. He wrote the opinion, but if we're going to look at the type of activity, when are we going to start? We're going to start looking at the type of land. I mean, unless beach day is the activity, beach day activities are a specific type of activity. I think that's where I don't think you can go that far, and you have to just say that this is the type of activity, which is a child playing, and that's something that a landowner should be able to have sufficiently warned anyone of that type of activity.
Is it relevant at all that a child who's running around and who's eventually injured by still burning embers is only likely to be injured in that way outside and not inside? I suppose it's theoretically possible it could occur inside.
Theoretically possible, but no, that's more likely to occur outside.
Is that relevant to the analysis here?
I think it's relevant to the analysis to the extent that it has some relationship to what the landowner should be doing in that situation. I think when you're, that there's fires there, there's a continuous series of fires outside, then maybe you should warn those people that are coming onto your land and let them know that. I mean, it seems like, even appellate counsel stated this, fires like these happen all the time, and I think that that's something where, does the legislature really want to relieve the landowner of that responsibility when there's dangerous activity occurring?
That goes to the gross negligence aspect of things, not to whether it's an outdoor recreational activity, right?
Not necessarily. This is just, I think, an immunity where they would have no ability to, or no requirement to even warn. I mean, I still have, if immunity doesn't apply, I still have the underlying negligence case to pursue, and there has to be some sort of relationship to what warning would occur, or should there have been a warning. So I think there's still that second half where this is just dealing with the immunity, saying that you don't need to even warn them, even though such a dangerous activity is occurring on the property. And that's what I have trouble with the legislature thinking that that would be okay.
Council, how is sightseeing a high-impact activity? Help to make that argument.
Sightseeing, the definition I think I cited is to travel about places. I think that's a traveling from place to place. There's some sort of ability that I would think a landowner maybe couldn't accurately or effectively warn someone who's sightseeing, because it includes the definition of traveling. I mean, you can take that for what you will, but that's why it's more difficult to warn a licensee on the property.
So you distinguish it based off of?
Well, the definition is to go about and see sites of interest.
I see.
So I think that's a distance type, traveling type argument.
And so you think there's like an impact? It's more of an engaged activity.
I think it's it has, I agree that it has the intensity, if that's what you want to call it. I would say the opposite side of intensity is also a difficulty to, a higher burden on the landowner to warn or police their land, or it's kind of the inverse of that when they're traveling across the land.
So how would you articulate the test that you think, it sounds like you don't completely endorse the Court of Appeals approach.
Well, I think there's just a different way. I do. I have no problem with it.
I know you'll accept it. But
think
if you were to write it yourself, it seems from your briefing at least that you.
Well, I think the three elements, because we have to go back to a trial court and tell them what to look at. What's the probability of the harm that that an injury could occur on the land? Even appellant thinks that a covered bonfire could be pretty high. You have the level of injury that could occur, which in this case was rather intense, and you have the burden on the landowner on how high of a burden should we put on them to actually warn the licensee of any potential danger on their property.
So the test we're going to give the trial court is any other outdoor recreational use of private property is covered by the act if it, fill in the blank for me.
I mean, if it has a high probability or a probability, I don't know how high the probability is, but it's a probability.
Similar inherent risk as
of the enumerated activities that could lead to serious injury like hunting, and that could have, that has a high.
It's getting long and sprawling.
Burden, sorry. a burden that is too difficult for a landowner to comply with under negligence law.
Would you disagree with me if I was to say that your test makes a lot of sense, but for the fact that we have a recreational act here? In other words, if there were a common law standard, your expression or statement of that standard might be fairly close to what the common law requires, but we have an intervening statute here that renders things a little bit more difficult for your position.
I think the Cyroyak case implied that the whole purpose of the Recreational Use Act was to codify common law. That's probably not binding, but it's I think where my argument's headed with this. And I guess when you're looking at the unifying activity, you still have to see whether the legislature would want to immunize these additional activities that they could easily warn a licensee. But I have nothing further.
Any further questions? Okay, thank you, Counsel.
Thanks.
Any further time left? Okay, your time is up. Thank you. The case will be submitted.